Hi everyone. So today we are going to be answering questions that you have sent me. If you are watching this live, go ahead and put your questions in the comments because I will be answering your questions as I go along. A lot of the questions I received was ahead of time. So people sent me questions ahead of time, or people commented their questions ahead of time. So I'm able to just go ahead and respond to those questions. So if you have questions about US based immigration, I always have to be specific that it's US immigration, because I do get questions about immigration to Canada and all of that. I cannot help you with immigrating to Canada, but when it comes to immigrating to the US, I'm your girl. So feel free to put your questions in the comments if you're joining me live. And then if you're watching this on a replay, feel free to ask me questions again. Like I said, people do ask questions under my videos, and I answer your questions, and sometimes I answer those questions on the live. So that's what we're doing today. I will be answering questions that people have sent me ahead of time, and your questions if you join me live. All right. So if you are new here, I am attorney Lillian Chukura. I run and own Lily Legal, which is an immigration law firm, and we help our clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. So let's jump right in. Again, if you have questions, put them in the comments. Just for people joining to know that you can send me questions. All right, so let's start with the first question I have here, which is about financial support. So, what would be your expertise on proving that a couple is together for love and a long life together, outside of how much time is spent on the phone, video call conversations for long distance spouses, and financial support provided within that relationship? Well, when it comes to proving that your relationship is real, the more documentation you have, the better. So, seeing each other in person, right? That's one thing. Making sure that there's communication. And I know this person is asking besides communication, but when you are not living in the same country, what you really have is the communication. So don't discount your communication. Okay. I always tell clients, because a lot of us communicate with our family and friends outside of the US through WhatsApp. WhatsApp has a feature where you can actually download your history with that person. So your text history, your pictures, all of those things, you can download it and you're able to print that out or print out sections of it for your visa application for your spouse or your fiance. So do not discount the communication because, again, if you are not living in the same country, USCIS is not expecting you to have like a joint bank account, a lease together, and those other things. Just keep that in mind as you are filing these things. Do not think that the filing requirement or the document requirement for spouses living together in the US is the same for spouses not living together, especially when one of them is living in a separate country. The requirements are completely different, so you want to make sure that you are not overthinking it. Okay, don't overthink it. Look at what you actually do have and make sure you are providing enough documentation for that. All right, so Keith has a question. Let's see. If I apply at US Embassy or consulate, how long is the process? Oh, sorry. There's a addition. Okay. If I apply for a US passport at an embassy or consulate, how long is the process? It depends on the embassy or consulate. There is a priority given to US citizens when it comes to their needs. So most embassies typically within a month, you will have an appointment to get that done, but it all comes down to the embassy, what their wait times are. But all embassies, all U.S. embassies give priority to U.S. citizens and U.S. citizen services. So getting a U.S. passport or renewing your US passport is going to get a priority versus someone trying to get a visa to the US. So for most embassies, we are seeing a month or two on that wait time to renew a passport. If you are doing a consular report of birth abroad, that one really does depend on the embassy, because some embassies you can get an appointment within a couple weeks for a consular report of birth abroad. And then for some embassies, it can take 4 to 6 months to get an appointment. So again, each embassy is different. Just wanted to cover both of those just in case you're talking more about the CRBA versus renewing a US passport that you already have. All right. So the next question, good morning. Oh, good morning, Emeka. My asylum was denied within 4 months. I applied with BIA. Appeal is pending with BIA. Can I apply for EAD? It depends. Okay. It depends on how long your asylum application was pending before it was denied and before you appealed to the BIA. So if your asylum application clock, right? So when you file for asylum, there's an asylum clock. So if that clock reached 180 days, then you can apply. As long as you can show, right? So you can apply as long as you can show that you filed your appeal within the time period given to file appeals. Okay, that's the key there. Because once your asylum is denied, typically in immigration court, you have the chance to appeal that decision. In order to appeal that decision, there's a time frame. And as long as you filed your appeal within that time frame and your asylum application was pending for 180 days before it was denied, you would be able to apply for an EAD, which is a work permit. Okay. But all those things have to be in place to be able to do that. And then on top of that, it's still discretionary whether USCIS approves it or not. It's not a must that they approve it, but it's still going to be discretionary. All right. So if you're joining me and you have immigration questions, please put them in the comments. Thank you, Keith, and thank you, Emeka, for the questions. All right. So as I wait for your questions, I'm just going to go ahead and, again, answer the questions that people sent ahead of time so that we can get educated together, right? Because some of you may have these same questions and you're not feeling comfortable asking online. So let me help you out. And if you're getting value out of this live, out of this video, please hit the like button. It just helps me know that this is something you want to know about, and I can give you more information on. So the next question I have here is about the new parole in place program. What is the current status? Can I still apply for parole in place? Well, yes, you can still apply for parole in place, even though there's a lawsuit. Well, now there's 2 lawsuits instead of 1, right? Before we were just dealing with 1 lawsuit. Now there's 2 lawsuits that's going on at the same time. So we are waiting for those to resolve. But in the meantime, USCIS is still accepting applications for the parole in place program. So if you have not applied yet and you qualify, you probably should go ahead and file your application, because I've mentioned this a couple of times, is if the judge, if the court comes back and says, okay, we're going to stop the program, but you can go ahead and approve the applications you already have, and your application is not in the mix, now you've missed out, right? But technically, the court can also come back and say, USCIS, you cannot move forward with this case at all. So it's completely up to you, but just weigh the risk and reward of filing versus not filing. So basically, quick breakdown of the timeline that we are working with. On August 19th, the court, USCIS started accepting applications for parole in place. On August 23rd, Texas and 15 other states filed a lawsuit to stop the whole thing, as they always do. And then on August 26th, the court came back and said that they're not going to make a decision yet, but they're going to pause the program, but only as far as USCIS is not able to approve applications, but they can accept applications. Okay, that was fine. And then on September 4th, the court, the same Texas court, came back and extended that for another 14 days and set a deadline for September 23rd to be the date that everything, that they make a decision on whether things are going to move forward or if they need to do another extension. They were supposed to have a final hearing on the actual trial, right, on September 18th. September 18th has already passed and there was no trial. Okay. The reason that there was no trial and we do not have a decision date is because on September 11th, there was a lawsuit filed in the Fifth Circuit Court in federal court. And this lawsuit is by families that will be affected by this program, that will benefit from this program, asking the court to allow them to join that lawsuit. Because right now, the Texas lawsuit does not include the families, right? The families that will be affected by a judge making a decision saying that the parole in place should be canceled. That lawsuit does not involve the families that will benefit from the parole in place program. So the families want the federal court, the Fifth Circuit Court, to basically say, yes, you can intervene and be part of this lawsuit. The Fifth Circuit Court also said that the Texas court cannot have their trial, cannot make a final decision until the Fifth Circuit Court is done hearing the families and making a decision. Because, again, this is the families wanting to intervene. And if the Fifth Circuit Court says that the family can intervene, but the Texas court already made a final decision, it's just going to be a problem. So, because this lawsuit in the Fifth Circuit Court affects the Texas lawsuit, everything is on hold. The parole in place program is on hold until there's a decision in the Fifth Circuit and then the trial in the Texas court and then hopefully a decision, a final decision. So yeah, it is, we kind of saw the lawsuit coming, but it's just a lot. The intervening lawsuit in the Fifth Circuit Court is a good thing, right? It's a good thing. It's not a bad thing. It's just going to stretch out the time before there will be a final decision on whether USCIS can go back to approving applications. So, hey, just keep that in mind. But if you qualify, just know you can keep applying. None of these lawsuits or pauses stops you from applying. It does not stop USCIS from processing your application. The only thing it stops USCIS from doing is actually approving it. So they can get your application up to the point of approval and they're just waiting for a decision from the courts before they can then go ahead and approve you. All right. So it does not hurt to apply, just in case. All right, so I see a question here. If your husband died and your papers was already in, what's the next step? The next step is you want to schedule a consultation with an immigration attorney, because depending on where your case is, you can basically turn it into a widow petition. Right? There's something called a widow petition that you can apply for as long as your husband is a U.S. citizen. That's another thing to keep in mind. And depending on where you are, whether in the U.S. or outside of the U.S., the process is going to be a little different. But USCIS needs to know that your husband died, and you have to notify them within a certain amount of time of his death. So you definitely want to consult with an immigration attorney to just make sure that you are within that timeline and that you do not miss the space that you have to actually file that update with USCIS and get your application to continue, because typically when the petitioner passes away, the application dies with them. But since the petitioner is the husband, that would not die. It will just change to a different type of petition. So don't give up hope. There is things that can be done. You just need to take the steps to get them done. All right. All right. So next question. This is in regards to step parent stepchild relationships, because a step parent can file an immigration petition for a stepchild as long as the marriage between the step parent and the biological parent took place before the child turned 18. Okay, that's the legal requirement. So if the child was under the age of 18 when the step parent married the child's biological parent, then they qualify as step parent stepchild for immigration purposes. All right. I'm not saying that, if the marriage didn't take place before 18, that there's no step parent stepchild relationship. I'm just saying for immigration purposes, there's none. All right. What if the stepchild is now an adult, married with children? Can the step parent still file for his or her or them? Well, yes. So even if the stepchild is now over the age of 18, is an adult, is married, as long as that step parent relationship was created before the child turned 18, they remain a stepchild for immigration purposes forever. Okay, so there's only like certain exceptions to that, but it doesn't matter how old they are today, as long as you are able to file for them. So it doesn't matter if the stepchild is an adult, as long as they meet the legal requirement for immigration purposes. So the step parent can file for the adult married stepchild. But because they are now an adult, it will be a preference category. And because they're married, it will take, right now it's taking about 15, 16 years for a visa to be available for a married child of a U.S. citizen. Okay, that's how long it's taking right now for a visa to be available. But once that visa is available, the stepchild, that's the married child of a U.S. citizen, can now not only get their own visa, but since they're married, their spouse and their children can get a visa under them as derivatives. So it takes time, but it is completely doable. All right. So again, if you are joining me, feel free to ask your questions in the comments. If you do not have questions, that is okay. We did get questions ahead of time that I will be going through, because I want to make sure that I touch on a few of these things today. So if you have questions, don't be shy. Ask me in the comments, okay? And if you're watching this on the replay, also put your questions in the comments. All right. So this was regarding 221G letters. So when you have a interview at the embassy, if they refuse you the visa, they give you a letter basically saying why they refuse the visa and what you can do to fix it, or if there is something you can do to fix it. Right. So if there is, so if they refuse it, you'll get that letter. It'll tell you what to do. So this person is asking, I wasn't asked for any additional documents. They just returned my passport and told me they will contact me. So if that becomes the situation where you went to your visa interview and the embassy did not give you did not take your passport, and they basically said, we'll get back to you, right? That is a refusal, but not a final decision. So a refusal and a denial are two different things, right? If you go to your interview and let's say your medical exam report has not come out yet, so they can't actually approve you for the visa, they're going to refuse you the visa. That does not mean they denied you the visa. It's just they're refusing you the visa because they don't have everything they need to make a decision yet. So for this person that went to an interview and they said, we'll contact you, most likely their case is going to be in administrative processing. And when it is in administrative processing, there's not really a lot you can do right away. But depending on how long it's been on administrative processing, there is something called a mandamus lawsuit where you sue the federal government for taking so long, right? So it's really important that when you're going to your interview, you know ahead of time that a refusal is not a denial, one, but that you remember every single thing that the officer asked you and everything you said, everything that happened from the time you walked into the door to the time that you left, because that's what's going to help us as the lawyers figure out what is going on. Is it administrative processing? Is there, red flags that came up at the interview that's making the officer question the relationship or whatever it may be. So it's really important that as you are being scheduled for an immigrant visa interview, that you remember every single thing, because that can make all the difference. The more we know, the better we are able to assist you. All right. Okay. Elna, how do you follow up on work authorization? It's been 8 months now. So there's a couple ways that you can follow up. You can do a service request. So you can do a service request on the USCIS website if your case is outside of normal processing time, right? So that's really the key here. There's the service request, but your case has to be outside normal processing time. You need to know your case's processing time to know if it's outside of normal processing time. All right, that's number one. So if it is outside, you get a service request. You call USCIS and request a service request. Okay, and do a service request with USCIS. You can also do that on the website. Okay, you can do it yourself on the website, or you can call them and do that request. The request, I'll be honest, it doesn't do a lot. It really doesn't do a lot. If they still haven't gotten to it, they'll just let you know we haven't gotten to it yet. That's what they're going to say. But just know that's an option that's available to you. Another option is an expedite request. An expedite request is basically saying there's an emergency, there's a financial situation, financial hardship is a big reason for USCIS to expedite work authorizations. Another reason that they will expedite it is if you have a job offer, right? You've received a job offer, you have that job offer, you can request an expedite request, because all the employers will not hire you unless you have a work authorization. So they can give you a job offer, but most of them that give you a job offer is going to be conditioned on you being able to it's going to be conditioned on you being able to legally work in the US. And in order for you to legally work in the US, you're going to need that work authorization. So you want to make sure, right? You want to make sure that you are applying for an expedite request if there is financial hardship, if there is a job offer that you just can't accept because you're still waiting on that. You want to go ahead and do that. The job offer expedite request for work authorizations. I'm not talking about green card applications, okay? Travel permits, that's not what I'm talking about. Just for work authorizations, to do an expedite request, having a job offer, having financial hardship, things like that, will help you to expedite your case. All right. I hope that helps. So service request, expedite request, you can do the service request on the USCIS website. But for the expedite request, you need to call USCIS and request it. Okay. And you need to have the documentation for proof of the emergency. So proof of the job offer, proof of the financial hardship ready to go as well. All right. Hope that helps. Hi, Mary. So good to see you. Thank you for coming. Um, as always, if you're joining me, you have questions, put them in the comments. But it's so nice to see you, Mary. Thank you. All right. So next question is Rosalind. What happens if you were scheduled for interview before USCIS received your response to RFE? It's up to USCIS. So if you have an interview scheduled, you go to your interview, right? It doesn't matter if there was an RFE that you responded to. It doesn't matter anything. If you're scheduled for an interview, you go to your interview. If you don't think USCIS received your response, bring a copy of what you sent in with you to the interview. That's what I can tell you. But does not matter. Does not matter if they received the response. If they scheduled you for the interview, show up for the interview, and then just to be on the safe side, you may want to take a copy of what you sent in as the response with you to the interview, just to cover all your bases. But key here is do not miss that interview. All right. Hi, Keith. Okay, which one is better, a passport or a certificate of citizenship? Well, it's not one is better than the other. So the certificate of citizenship, if you're doing a CRBA, Consular Report of Birth Abroad, you must get a certificate, right? That's the CRBA. You need the CRBA to then get the passport, unless you were born in the US and you have your US birth certificate. Okay, so it's two different things. It's not like one is better than the other. If you have a certificate of citizenship, but you don't have a passport, you cannot travel. So so they do two completely different things. So the certificate of citizenship is to show that you are a US citizen. The passport is to show that you're a US citizen and you are able to travel. Without the passport, you cannot travel. So it's not one is better than the other. It's just what is your particular situation, and are you able to do one or the other, right? So if you're planning on traveling, you need a US passport. If you're trying to register the birth of a child and show that this child that was born outside of the US is a US citizen at birth, you need to do the Consular Report of Birth Abroad, which will get you the certificate of citizenship, and then you use that to get you a passport. Okay, so I hope that makes sense. Okay, so Samba, you only have to send your question once, okay? I see it. So you don't have to send it multiple times. Just once is enough. Okay. So question is, without waiting for removal based on asylum, can I get married to a US citizen and get green card? It depends. So in order to apply for a green card in the US, you need to be admitted, paroled. So if you were inspected and admitted to the US, so you came in with a visa, and that visa is one that you can adjust your status with, then getting married to a US citizen can lead to you getting your green card. However, it's not, a straight shoot, right? If you were paroled, the question is, are you an arriving alien? Because if you are in immigration court proceedings, you may need to apply for your green card in immigration court. So you're not able to apply for the I-130 and the green card application with USCIS. You will only be able to apply for the I-130 with USCIS, wait for that to be approved, then go to the immigration court and apply for your green card. Again, this is only if you were paroled or you came in with a visa that allows you to adjust your status. If you were not paroled and you did not come in with a visa that allows you to adjust your status, then that is not an option. Okay, it's going to be a longer option that will require a waiver and everything else, and require you to leave the US at some point to get that visa. So it's important. So it's not like a straight shoot question. It just depends on your particular situation. If you want to know if you specifically or the person you're asking about can apply based on their particular situation, go ahead and schedule a strategy session with me, because I will be able to then see if they were paroled or admitted, and if they are an arriving alien that can apply for everything with USCIS and then get their court case dismissed, or if they are not an arriving alien that needs to do an I-130 with USCIS and then get their and then try to get their court case dismissed to file a green card application with USCIS, or file the green card application with the immigration court. So the options depend on the person's particular situation. So that's why on these, I can give you the general information, but if you really want to know if the person qualifies and if they can just go ahead and apply for that green card, schedule a strategy session. And you can do that directly on my website. If you go on my website, lilylegal.com, and click on contact us, you can actually pick a date and time for us to speak about this particular situation. Okay? All right. Oh, Elna, I'm so glad it was helpful. And honestly, I do these lives, I do this Q&As because when my family was going through our immigration journey, we did not have anyone that we can ask questions to even get basic information, talk less of doing a consultation. So I am thankful for the internet. I am thankful for a space where we can actually talk about US immigration and get you the basic information you need to make the right decisions for yourself and your families. Because doing this in the 90s and early 2000s was a lot. It was not easy, and there was nowhere to get the information. So that's why I do these. I love doing these lives, and I love answering your questions. So feel free to put them in the comments if you're joining me live and you have questions. If I don't see any other questions, I think we may be good for today. So last call on questions. And as I was, telling Samba, if you are wondering if you qualify for a specific immigration benefit, or if you want to apply for green card citizenship, feel free to schedule a strategy session with me. It's a free 15-minute time for us to talk about your situation and get you on the path of what you need to do next. Okay, that's one thing I promise everyone that I meet with. You will know what to do next after we speak, whether it's filing for something else or, oh, okay, I just have to wait. And sometimes it's just you have to wait, but you won't know that and you'll stay there stressing. But instead of stressing, come talk to me. Let's figure it out together. And then if you want to work with me, we can do that as well. Okay, Elna has another question. I have another question. I applied for asylum 8 years ago. Up to now, no update. They just continue to renew my work permit. What route should I take? So, honestly, that is normal for everyone, unfortunately. Right? Unfortunately, that has been absolutely normal, par for course. So, they started, a few years ago, they started doing last in, first out. Basically, that means is someone that applies for asylum today will get an interview. Is more likely, let me say that. Someone that applies for asylum today is more likely to get an interview within a few months than you that applied 8 years ago, because they just want to get the newer people out to make a decision on the asylum, see if they're going to be approved, and move their case out. And then with the people that filed before, they're trying to get to those, but it is going to take some time. So yeah, just keep renewing your work permit. If there has been an extreme change in country conditions, if there is an emergency situation that requires an expedite, then you can request an expedite for an asylum case, right? You can request for an expedite, but it needs to be, you need to show the extreme situation. So humanitarian reasons or safety reasons to expedite your case. Right. Another thing that you can do, or that we have done for our clients, is put them on the short list. So some asylum offices, right? Not all of them, at least I haven't worked with all of them, but some of them have a short list, which is basically you basically get a short notice, okay? Short notice that there's an appointment available on this date at this time. Do you want it? Yes or no? If they call you and you do not pick up, it goes to the next person on the list, right? They just keep calling until someone says, yes, we want it. So that's another option, is to check if the asylum office has a short list and to request to be on the short list. One thing I will tell you though is the short list is not short. At the Boston Immigration Office, I believe the short list is about 30,000 deep. Okay? The short list is about 30,000 deep. So it's not, it doesn't really move things along faster when a lot of people are requesting to be on the short list and there's just not enough interviews for that short list to move along. So one thing I will tell you is it's not about you and it's not about your case. Okay. The reason that you have not gotten an interview in 8 years is because the asylum office is severely backed up and they do not have enough people working there. Has absolutely nothing to do with you or your case. So just remember that. If nothing else, remember that and just hold on to that. But completely normal to not have an interview after waiting 8 years. It shouldn't be, right? It should not be normal, but that's the normal that we're living in with asylum cases. So just keep that in mind. All right. So I don't see any additional questions. Let me just check over here. All right. All right, so no additional questions. If you do have questions and you're watching this on the replay, or you leave this live and you think of a question, come back. This video is always on my YouTube channel and always on the Facebook page. So you can go on the YouTube channel and ask your question on this video, okay? Or any of the videos that you watch, you can ask me questions there related to that video, because like I said, I do go back and respond to those questions. And then when there's like really great questions in there that I think you all will benefit from, we put that in the Q&A. So feel free to do that. And thank you all so much for joining me. I always enjoy these, and you all have such great questions as always. So thank you so much. And I will see you next time. Have a great Friday and have a great weekend. Okay? Okay.